Hello everybody. Just before we start this evening, I've got a few words on housekeeping, as you would expect. Firstly, can I just remind everybody to turn off their mobile phones or put them on silent? We do have a fine system at CFAB, so you won't like that. Secondly, there are no fire drills planned for this evening. So if you do hear the fire announcement, then follow the instructions that you hear. The fire exits for this room are the doors that you came in. There's one on either side. When you enter the building, you were given a security pass. That's the only thing that will get you out of this building, so please don't lose that either. Can I just also mention that I think we'll probably have more people arriving. It's an early start this evening, and I think that to cause the least amount of disruption, if you can sort of shuffle along and let people just squeeze onto the end of those rows, that would be very, very helpful. And lastly, if any of you are avid social media activists, then we would urge you to get posting using the hashtag ICP Lecture 2018. And now I'd like to hand you over to the CEO of CFAB, Carolyn Housman.
Great. Thanks. I'm going to stand here because I am going to be clicking through a few slides. So good evening, everyone. I think we were expecting around 150 tonight. And just to get a sense of who's in the room, just quickly by a show of hands, how many of you are working directly on the front line with children? Okay, maybe 60%. And for others, are you working indirectly, policy, fundraising, that sort of thing? Go ahead and raise your hand if it's indirectly. Yeah, about 10, which means some of you probably just followed everybody else into the room to see what was going on. Well, you are definitely in for a treat tonight. As Tom said, I'm Carolyn Housman. I'm CEO of Children and Families Across Borders. I'm your warm-up act tonight to the main event, Sir James Munby. CFAB hosts our International Child Protection Lecture every year, and I'm really pleased to say that we've had a long list of wonderful speakers, including Isabel Trowler, who is the Chief Social Worker for Children and Families, Baroness Butler-Sloss, the first female Lord Justice of Appeal, and of course Lady Justice Black last year, and we're absolutely delighted to have Sir James Munby, former President of the Family Division of the High Court of England and Wales. He hardly needs any introduction, of course, given his unique impact on family justice reform during his esteemed career, and I'm very much looking forward to hearing from him in a few minutes. I also want to say thank you to Clifford Chance, who's hosting us here tonight, providing all of the refreshments. Jo Ford and her team have been absolutely delightful to work with. And I do need to say thank you to Angela Wilson, who co-authored the research that many of you picked up on your way in. Without her diligence, that research definitely would not have been possible, and I'm really looking forward to talking about it later tonight. So thank you to all of you for coming. I'm sure you will agree that now more than ever, in a changing Britain and changing world, it is crucial to think about how we can best protect children across countries, nations, and borders. So, who is CFAB? We are the UK branch of International Social Service, present in 130 countries around the world. The ISS network was set up just after the First World War to cope with the millions of refugees across Europe. And if you are interested in the history, it's very interesting, so please do look us up. Of course, many of you will have known us as ISS UK or ISS GB, and in 2010 we changed our name to Children and Families Across Borders. So what do we actually do? Research is one of the bedrocks of what we do, and I will be talking about our latest piece of research in a moment. We also have a free national advice line that's staffed 9:30 to 4:30 Monday through Friday by our excellent social workers and our caseworkers. We do international casework, so you could describe us as the UK's hinge, which opens the door to inter-country casework carried out by our partners abroad. We facilitate overseas assessments, placement support, guide our in-country social work partners. This might be on timescales or managing expectations around what the UK court requirements are. We also do capacity building, both here in the UK and abroad. So just last week, our principal social worker, Noriko Takahashi, was in Bangkok with colleagues delivering training there. And the week before that, she was in Hillingdon. So she does get to go to all of the exotic places. And then finally, we do a bit of advocacy. We have a platform here at CFAB, and we do use it to advocate for the best interests of international children and their families. Okay, I mentioned our research. In September this year, we published a study on cross-border child safeguarding. We wanted to capture the unique insight that we have into the international facet of child protection. Our investigation was all about informing practice and policy in relation to children in need of protection who travel abroad, and children in the social care system who have the potential to be placed with family members abroad. It is, of course, important for me to set the scene a little bit and to note that we audited 200 case files from CFAB and tested our findings through focus groups with social workers, solicitors, CAF guardians. We also conducted a review of existing literature in the field. However, the CFAB case audit is not representative of the national picture, as the sample was created from cases referred to CFAB. And of course, not all cases go through CFAB as much as we might like them to be. So, bearing this in mind, what did we find? A big takeaway from the research was the sheer variation in quality between local authorities in their knowledge, in the resource, and the level of post-placement support that they could offer to children. Local authorities and organizations across the country are doing things different. So the research certainly raises the question of where is the benchmark for quality and who is controlling for that? Despite the efforts that were recorded from social workers and other professionals, a quarter of the children reviewed who were in need of protection and who left the UK remained at risk of abuse and neglect. This is down to the fact that it was not possible to safeguard them once they left the UK. On average, our research told us that it took 45 days for us to get information from a local authority to send out a child protection alert internationally when a child in need of protection traveled abroad. Now, our own policies within CFAB is to issue an international child protection alert within 24 hours. So what is prompting that delay of 45 days from the local authority getting that information to us? Well, there were two key factors there. One was around the fact that the local authority might not know to which country the child had gone to. And the second was a lack of understanding amongst professionals of what to do. So this is about the level of knowledge and awareness within local authorities on the right procedures to follow when a family flees abroad. We found that in 1 in 3 cases where we knew the outcome, they resulted in an international child placement. And by the way, we would love to hear from you guys, those that do already work with us. If you do know the outcome of a case, let us know, good or bad. It helps to inform our own practice. Unfortunately, in the case audit that we had, 45% of the time we didn't know what the outcome from the case was. But in those that we did know the outcome, as I say, we saw that in 1 in 3 times a child was placed abroad. So this should tell you that overseas placements are a viable option. And I certainly hope this has you all thinking about how you might be better advocates for families across borders in the future. Certainly in an increasingly globalized world, considering family members abroad must be one of the options for children. We had lots of other findings which gave a snapshot of how local authorities are practicing at the moment. Interestingly, we found that potential carers are increasingly being invited to the UK from overseas to be assessed here. That was something that, when brought up in focus group, professionals told us that worked really well for them. We also found that the courts needed to take better into account what the local support systems were when a child is placed abroad. As we saw in 2 of the cases where there was family breakdown, we had already raised concerns about the lack of local support systems for the family or the fact that they were not able to access it. We found children were placed in the UK even where a local authority had completed an initial assessment that raised concerns or where no assessment was made at all. So that's a bit worrying, to say the least. As I say, we found out about cases where local authorities had refused kinship assessments from abroad and then the child was placed here without one. When we talked to social workers in our focus groups, they had a lot of anxieties about the long-term outcomes for children who were placed abroad. They were afraid that they would be less likely to be informed if there were any hiccups in the placement or indeed if that placement broke down. And they weren't really sure what power they might have to do things if there were problems abroad. So, what do we make of all of this? We have some recommendations, of course, which we think will provide some of the pieces of the jigsaw from our social worker, legal, and policy colleagues that we as a sector could use to improve children's experience of cross-border placements and cross-border child protection. And when we say pieces of the jigsaw, we are talking about one of those really hard 1,000-piece jigsaw puzzles that you just want to cry and you feel like you're never going to get to the end to, but you just keep plugging away at. And unfortunately, child protection is one of the most challenging problems that we face within society. And when you add the international element, you might be thinking, what more could I possibly do? But there are some quite simple pointers from the research you will be thankful to hear. We think that practical guidance is needed when a child in need of protection travels abroad. Ideally, practitioners would have a working knowledge of the UK processes for border alerts and child protection alerts, so they can act quickly if there is the need for it. For relevant cases, they would also know to try and get crucial information from the family when they do their everyday home visits. So that might be about the details of any family members residing abroad. We think that clarification is needed on the responsibilities of UK local authorities when overseas requests come in. So that's particularly around kinship assessments here for children in care abroad. There should be clarity of process and to bypass any uncertainty and speed things up for children. We think that there should be routine follow-up from agencies which are aware of a potential UK placement from abroad. For example, CFAB, the central authority, and UK local authorities should seek to confirm down the line whether or not a child discussed was placed here in the UK. And doing this would mean that the local authority could take action if they were worried about that child's placement. We think that more practical guidance is needed around international placements. We could be clearer on appropriate legal orders for international placements and information on how local authorities can continue to offer relevant post-placement support even when a child is placed abroad. And finally, we want to know more about professionals and carers crossing borders. There needs to be more research around the impacts of sending UK social workers abroad or using social workers from overseas, and also how inviting prospective carers here to the UK for assessment might impact on placements differently, positively or negatively. We don't really know, and it would be great to find out. So, there is a lot of work to do, but CFAB is here to help. We provide a lot of free support, including fact sheets on all sorts of topics on international child protection, on child placement, on kinship assessments, and even surrogacy across borders. We are currently running free international social work training sessions across the country. That's a full-day jam-packed session on international social work, and we've had fantastic feedback to date, so do get in touch with us if you're interested. We run our free national advice line to support people like you calling in for advice or signposting to other organizations. And as a charity, we run this unfunded national advice line at a loss because we feel it is so vital and so used by social workers in 80% of local authorities across the country. So that is my 15 minutes of fame over today. Thank you very much for listening. It's been a pleasure to talk to you about some of the work that we do here at CFAB. I hope that I have been a useful warm-up back to Sir James Munby, and I would now like to hand over to him for his keynote speech.
An apology and a disclaimer. I'm not a social worker. I'm a mere lawyer, and there's going to be perhaps rather too much law in what I have to say for your liking. And horror of all horrors, I'm going to start off very briefly touching on the fundamental principles of international law, which actually underpin what we're doing. And for present purposes, there are two key principles. The first is that a state agent or an official of state A, and that includes a social worker employed in this country by a local authority or an ISW appointed by the court, cannot operate officially in state B in a foreign country, and is either diplomatically accredited to that foreign country or with the consent of that country. And I'll come back to the implications of that for social workers in a minute. The other fundamental principle is that judges, and this is a principle of international law, their judgments do not have extraterritorial effect. So that I can make an order, sitting as an English judge, directing that something will happen in some foreign country. That order binds, is good as a matter of English law, it binds people who are subject to my jurisdiction in England. It has no effect on the foreign country, on the foreign jurisdiction, unless there is some international convention or treaty or international arrangement which departs from the normal principles of international law. And that, while jumping ahead, is why, of course, Brussels II revised, B2R as we call it, is so important. Because B2R is, for this purpose, an international treaty which enables us, for the time being and for the next 2 or 3 months, to escape from the fundamental principles of international law. And one of the problems, of course, which flows from these two principles is that if I make an order as an English judge saying, well, this child, in my judgment, in my decision, should move abroad and live in Ruritania, what is the effect in Ruritania, in Ruritanian law, of my order? And that involves what's called private international law, conflicts of laws. And the problem there is it is often surprisingly difficult for an English judge to find out what the relevant foreign law is. And if I can give you a recent example of this, very close to home. The question arose about 18 months ago as to whether an English judge could put an English child in secure accommodation in Scotland, the need for that being because there was no facility available in England. Well, the question of whether I could do what I did was a matter of English law. The question of the effect of what I was doing in Scotland was, of course, a matter of Scots law. And until the case had gone through the English High Court on the English end of it, and then through the Court of Session in Edinburgh on the Scottish end of it, nobody knew what the answer to these questions was. So there are very, very real problems unless one has an international arrangement. And we have to be very sensitive about this. There are many foreign countries which, for geopolitical reasons or historical reasons, because they think they're being lent upon by a country, the UK, which has delusions to grandeur and thinks of itself as a great power, or because it is a country which views the UK as the former colonial power, is very sensitive about what we do. And if a foreign country, if the courts, the official bodies of the government of a foreign country, think that we're simply taking them for granted, they get very upset indeed, and they're entitled to. So that's sort of very shortly the international law background to this. Coming closer to everyday realities, we've got two problems in particular in this country. One is that for historical reasons, Hague abduction cases have always been dealt with by the High Court judges in London. And there is therefore in London a considerable degree of expertise in dealing with problems of international family justice. And by and large, most of the practitioners who are really expert in matters of international family justice tend to be based in London. And of course, in the modern world, where the kind of problem we're talking about tonight often arises in the context of care proceedings, they are not going on in the High Court in London, they're going on in the family court up and down the country. And I'm not criticising anybody, but the simple reality is that some of the expertise which in London we take for granted simply isn't there out of London, whether one's talking about the practitioners or indeed about the judges. And there have been complaints in recent years that judges who do not appreciate the sensitivities of international law have made orders, ordering foreign judges, ordering foreign countries to do things to the great offence of the foreign country. And that is why in the High Court, whenever we make an order which is designed to have an effect in a foreign country, which involves the cooperation of a foreign country, it is always expressed in terms of respectfully requests the assistance of the foreign country and nothing more, because otherwise the foreign country is entitled to become upset. And I think I'm right in saying, if you look in your passport, even your mulberry-coloured EU passport, you will still see at the front that Her Britannic Majesty's Principal Secretary of State hereby requests and requires, in the name of Her Majesty. Well, the Secretary of State does that, we don't do that. So there's a practical point here. It is very easy, if you don't understand this, to blunder into doing things in a way which causes great offence abroad. Conversely, the problem, a big problem in this country is because of settlement patterns, there will be individual places in this country which have particular knowledge of, particular experience of, and therefore particular expertise in particular foreign countries. So, for example, if there's a significant population of people from Ruritania living in and around Barchester, Barchester County Council and the Family Court of Barchester will know an awful lot about international family justice as it interacts with Ruritania. But that knowledge is not, by and large, in any way accessible to everybody else. And therefore, if you have a Ruritanian family raising a Ruritanian issue outside Barchester, first time ever, where do you turn for help? Well, some of those with nous may perhaps get in touch with CFAB, and CFAB may be able to provide the answer. But I think there's a serious point here, because I've discovered anecdotally that, for example, there are increasing numbers of local authorities who, partly because they're looking abroad for expertise and partly because they are concerned in their particular area with the issues rising in particular countries, are employing people, social workers and lawyers, who have family and professional connections with particular foreign countries. Now, that's a tremendous resource we have here. But how, again, does one find out where those resources are? And I've long thought, and a demonstration of the futility of my time as President of the Family Division, I bang my head against brick walls suggesting this, that we need some kind of central mechanism, an information hub, to use the modern jargon, in relation to which, putting it very simply, somebody, a judge, director of social services, social worker, lawyer, could get in touch and say, look, I've got a problem involving Ruritania. Is there anybody out there, whether a local authority, a judge, a social worker, or what have you, who has experience of dealing with Ruritanian cross-border issues? Well, we don't have that at present. And the result is that I fear that there's a large amount of expertise out there which is not properly tapped. And the consequence of that is that people stumble around trying to reinvent the wheel, when in fact the design of the wheel, if one takes, for example, transient agricultural workers who have moved into Lincolnshire and the Fenlands recently, you really got to go to Peterborough, look at Fancourt of Peterborough, to get a vast amount of information about the realities of cross-border issues as between this country and Eastern Europe. Then there are two further legal problems. One is, if we don't have an international convention like the Hague Convention or Brussels II, what do? We have to find out what the relevant foreign law is. And it is surprisingly difficult actually finding out what the foreign law is, often. And there are two reasons for that. One is that foreign lawyers are not necessarily familiar with things which to us are very familiar, such as the concept of undertakings or mirror orders. So if one glibly writes a letter to some foreign lawyer who's very expert in the family law of Ruritania, saying what is the Ruritanian law in relation to mirror orders, it can so easily turn into a dialogue of the deaf. And the other problem is that cross-border issues, we as family lawyers tend to think about the family law aspects, often involve issues of nationality and immigration law. And certainly in this country, and I suspect equally abroad, the number of lawyers who are experienced and expert in both family law and immigration law is vanishingly small. And that is why, even if one's got a purely domestic issue, I mean, is there any point in making a Section 8 order in relation to mum if mum's about to be expelled by the Secretary of State and shipped off to Timbuktu? It's a very real problem dealing with foreign countries. And I don't know how many of you know what an orphan application is, but anybody who's been involved in that particular form of international child issue, which involves the application to place a child who's not an American citizen in America, pursuant to what's called the American orphan application process. And that doesn't apply only to people who you and I would think of as orphans. It means those who legally don't have a parent will appreciate and have bitter experience with the incredible complexities of dealing with 3 different systems of law. Because what one's trying to do on an orphan petition is to make sure the child is legally an orphan as it jets across the Atlantic, but was not an orphan before it left this country. And that involves the cooperation and the synchronization of 3 different systems of law: English family law, American nationality law, which is a federal matter, and then the relevant American family law, which under the American system is a state matter. And even assuming one gets, as one usually does get, the most enormous cooperation from our cousins across the pond, actually getting those 3 bits to mesh together is surprisingly difficult. Now, that's a very quick canter through some problems, but it goes to demonstrate, I hope, why we have been blessed, and it's not a political point, but we've been blessed by the fact that in recent years we've had B2R, which at least solves all these problems, at least in theory, within the EU. And of course, with the expansion of the EU, that now covers most of Europe. And of course, the last thing you want tonight is a lecture from me on B2R. But as you know, it covers the whole of the EU. And so far as concerns matters we're interested in tonight, it determines which countries' courts have jurisdiction in a particular case. It provides for the mutual recognition and enforcement of orders made by family courts across Europe. It enables the courts in one country to transfer the case to another country under Article 15 if the sending court thinks the foreign court is better placed to deal with the case. It provides, as you know, interstate mechanisms within Europe for state cooperation between central authorities, and under Article 56, it specifies the procedures which are to be adopted in cross-border non-family placements. So most of the problems which, apart from B2R, would be very real problems, are within Europe solved by B2R. Now, this inevitably raises the Brexit issue. What happens when we leave the EU and B2R ceases to apply? And there's your complete skeptic or cynic. That's going to happen on, is it the 29th of March next year? Well, the government's proposal, as you probably know, which reached us as recently as the 13th of September, when it published a document, Guidance Handling Civil Legal Cases. It's characteristic of government that a sort of footnote says, by the way, civil includes family, but the prism through which this is seen is civil law, if there's no Brexit deal. It announced that its grand plan when B2R ceases to operate is to replace it with the application of the 1996 Hague Convention. Now, 1980 Hague, you will all be familiar with, that's the Abduction Convention. Hague 96, you'll probably be much less familiar with, because in very large part it tracks, or B2R tracks, I don't remember which way around it is, the same approach. Within Europe, if B2R applies, Hague does not apply. And there aren't yet a large number of non-European countries are part of Hague 1996. And therefore it's not something we're particularly familiar with yet. But the government says, don't worry, we'll simply substitute B2R for Hague 96, and it's essentially the same, and government says it will be, quote, an effective alternative. Well, at first blush, I think there's a lot of force in that, to give credit where credit is due. I won't go through, but in the printed version of this, I give a little table saying, you know, B2R Article 8 equals Hague 96 Article this, and by and large the critical articles I've mentioned are reflected in Hague, and very often in very similar language. So, up to a point, Lord Copper, this may be an effective way forward. Subject, of course, to this, there will inevitably be initial teething troubles, but whilst people become familiar with what the present is unfamiliar. And there'll be an inevitable process which may take more or less time of familiarisation. But there is one important practical point, which actually I think the judges have got to grapple with very decisively at a very early stage in this. There's a lot of jurisprudence, as we lawyers call it, on B2R. There's a lot of case law which explains how B2R operates. There's virtually no case law, either domestic case law or international case law, on the corresponding provisions of Hague 1996. And it is always said, cynically, and with a certain amount of glee, by the lawyers contemplating their bank accounts, that any new piece of legislation guarantees 10 years of litigation for the lawyers. But we haven't got the luxury of spending 10 years working out what Hague 96 means. And my view is that we need, right at the outset, to assert dogmatically that unless there is clear authority that one has to construe Hague 96 differently from B2R, or unless the language is so different that one's driven to this, we should simply incorporate the whole of our thinking about B2R into Hague 96. That way we can get a reasonably seamless transition, and that way we can move forward quickly without letting the lawyers take all sorts of silly points. I mean, I have certain forebodings about this because those of you who are really nerdish lawyers will know that the family judges deal also with the court protection. And when the court protection was introduced in 2007, although a lot of what the court protection does and a lot of the jargon is the same as in the family law, there was a big body of court protection practitioners who said, oh, well, we know the point's been decided under the Children Act, but we're not concerned with the Children Act, we're concerned with the Mental Capacity Act. So we want to go all the way to the Supreme Court to decide whether the point is the same or not. Well, we've got to put a stop to that. But it is a really important practical point. Now, just tying up one particular loose end, when we leave the EU, as I assume we're going to, of course the European Charter will cease to apply to us. At the risk of putting my head above the parapet and being shot at, my own assumption, suspicion is that in the context we're concerned with, that is not a particularly significant change, because even if the EU Charter goes, we will of course still retain our membership, I hope, I believe, of the European Convention for the Protection of Human Rights and Fundamental Freedoms. The rabid rhetoric which suggests that we were going to get rid of that seems to be rather muted in more recent months. Now, sorry for all the legal stuff. Social workers. Now, 2 points, if I may. First of all, I've already touched on this. What is the legal position if a local authority in this country proposes to send a social worker to do some social work in Ruritania? And let's assume for this purpose that the English courts made an order approving that, sanctioning that. Is that all right? Well, the answer is maybe yes, if you're lucky and keep your fingers crossed, and assuming your director has remembered to keep you insured, but maybe not. And I've explained the reason why. And I think I'm right in saying there are some countries in Europe where it is a criminal offence to act as a social worker unless you're registered. And of course an English social worker won't be registered as a social worker in Ruritania. So there are real problems here. I emphasise the point because the very fact there's a problem is, I suspect, news to many. And the last thing we want is some great diplomatic incident with the Foreign Secretary trying to prize out of some prison in Ruritania some hapless social worker who, acting in complete good faith, has, putting it bluntly, been let down by the English system. So that's a really big problem. And I always think it's helpful in international context to test the thing the other way around. I mean, suppose you're headmistress of some primary school here, and suddenly one day some bod turns up and starts asking questions. And you say, "Who are you?" And the person says, "Well, I'm from Mauritania, and here's a Mauritanian court order so telling me to come and talk to your pupils." Well, what would our reaction be? Well, I suspect our reaction would be, "Well, that's all very well, but you should have discussed this and arranged this and coordinated this with our authorities before you just crash in." Now, put that way around, it's very obvious. Why should we think it's any different when it's the other way around? And the reason I'm afraid, and this comes back to my point before, we in our institutional, in our conventional arrogance think, well, we are English, we're British, we're all right. Other countries are rather different. And the fundamental point of international law is what's good for them is good for us, and vice versa. The other, and I hope I'm now getting near to what you're really concerned about. From the point of view of the child and of the child's family, and if we're talking about a potential placement of the child relatives in Mauritania, how and where and by whom should the assessment be carried out? Now, I'm not a social worker, but I hope I've got some views which are not so absurd that you won't raise too many professional eyebrows or start throwing things at me. But before I answer that question head on, can I just make a couple of points? The first is that attitudes in this country have changed remarkably in recent years, attitudes by lawyers and judges. It's now commonplace that the English court does not descend into chauvinistic comparisons between our system and the Mauritanian system, between English judges and Mauritanian judges, between English social services and Mauritanian social services, and that we take the view that, on the face of it, the judicial structures, the official structures, the social services structures in civilized foreign countries are, if different from ours, at least as good as ours. It's not for us to say, actually, we do a better job than you, and therefore we want to have an English social worker going out rather than a Mauritanian social worker. It's simply not permissible, by and large. This is the current thinking in this country, for judges to permit, let alone themselves to indulge, in a comparison of such matters as the competence, the diligence, the resources, or the efficacy of either the child protection services or the courts of some other state. Now, that's been a hard-learned lesson. 20 years ago, things would have been very different indeed. We are largely where we are as a result of, on the institutional front, the enormous endeavours of Sir Matthew Thorpe, Lord Justice Thorpe, who was years ahead of his time in preaching this, and eventually got English lawyers to accept it. And, of course, what's happened in the last 15 years or so, the combination of those two great benefactors of the modern world, the inventor of the Boeing 747 and the people who destroyed the restricted practice on airline tickets. We have cheap transport. And in recent years, we've seen great movements of peoples. We've seen great movements of peoples across the EU, in particular from Eastern Europe, and we're now seeing more movements of peoples. And the consequence of that is we're now becoming familiar with what other people do. And a lot of judges will have had a lot of experience in this country of reading judgments by judges across Europe and other countries. And what you discover to your astonishment, and the fact you're astonished is actually a criticism of us, not of them, is once you've translated the foreign language, actually, the jargon may be different, but they're doing the same thing as we're doing. They're addressing the same issues. They're concerned with the same fundamental principles. And what they're doing, whether it's some family judge in southern Italy, a family judge in Paris, a family judge here or wherever, is to do what's best for the child. And we've learnt the hard way that we can, as I'm very sure we must, have trust and confidence in the judges and the systems of other countries. Now, that is the English law if one's concerned with countries which are within B2R, within Europe. or within Hague, it's not quite so emphatically clear the law in relation to other countries. But my approach is that by and large, the starting point should be, unless there's good reason to take a different view, that the institutions of a foreign country are going to be doing their best to be doing what is needed in the best interest of the child, unless and until the contrary is discovered, is ascertained. So just because we have some country outside Europe, outside the Hague system, we don't write it off as uncivilized. After all, there are plenty of countries around the world who are not part of Europe and not yet part of Hague 96, and on any definition are civilized. Now, at this point, I suspect I may be cutting across something Carolyn's already said. This has a very important corollary, it seems to me. If one puts all this together, once the English court has decided the child should be placed abroad, and the child has in fact moved abroad in accordance with the English court's order, the ongoing responsibility for the child must, at least after what should be at most a short transitional period, be recognised as being exclusively a matter for the foreign authorities, whether the foreign country's social services or the foreign country's judicial authorities. I mean, otherwise, what basis do we have for interfering? We've sent the let's say it's a Ruritanian child, we sent the Ruritanian child back to Ruritania, the child's in Ruritania. What business is it of an English judge 3 years down the line to be saying, well, I've heard on the grapevine things aren't going very well. I'm going to start making orders. This is a very real problem, but I think one's got to be very, very careful before one falls too readily into the trap of assuming that once the child has gone abroad, after the interim transitional period, it's any responsibility of ours at all. And if we are going to, as the foreign country may see it, interfere, because that is what we are doing, we've got to do it very subtly and carefully and make sure that every stage of the process we are collaborating with the foreign authorities. And the problem may then be, well, they will say, well, I'm terribly sorry. There's nothing wrong with this child as far as we can see. We don't understand your concerns. Now, that leads me on to a wider point. And this may sound heresy, but it's something which has long troubled me. I question whether it's ever part of the proper function of the English court to carry out a comparative analysis of social, cultural, material, economic conditions in this country and in Ruritania, with a view to deciding which country might be thought preferable for the child to live in. Surely what weighs much more heavily in this are emotional, family matters, relationship matters, and so on and so forth, rather than the purely material considerations. And let's test it this way. If an English local authority, becoming aware of the fact that a Ruritanian family was proposing to move back to Ruritania with their children, tried to begin care proceedings on the basis that the local authority took the view that the conditions in Ruritania were so disadvantageous that the children should be taken into care, what would we do? Well, acknowledging there may be, I'd about to say, stupid people out there who will do the wrong thing, my suggestion is that in that kind of situation, it's no business of an English authority, an English local authority, or an English judge to stop a foreign family going back to their foreign country merely because we take the view, rightly or wrongly, it may very well be wrongly rather than rightly, that the child would be better off here. Now, what is interesting is that one searches high and low in reported cases for cases which either articulate this principle or even illustrate the principle. But there was one case which was notorious at the time, back in 1996, in the dying days of apartheid, South Africa. A Zulu boy had been brought to this country and was being looked after in this country by the white Afrikaans mother, the white Afrikaans woman, who'd been the employer in South Africa of the child's mother. And the question is, should the child remain here or should the child go back to South Africa? And Mr. Justice Thorpe then was emphatic that, as he put it, the child's development must, in the last resort and profoundly, be a Zulu development and not an Afrikaans or English development. And the Court of Appeal upheld that, although the Court of Appeal recognised that in material terms, economic terms, employment terms, the child would be in a much worse position in Zululand than in this country. And Lord Justice Alan Ward made the comment, he will leave the comforts of Maida Vale for the comparative discomfort of Brakpan, somewhere in South Africa, but so what? And I think that's a profoundly important point. Behind all that, there are the powerful words of Mr. Justice Mostyn. Now, the context was different. The context was a non-consensual adoption of an Eastern European child in this country. And what Mostyn said was, my decision will determine whether ED, the child, grows up in the Czech Republic, where a full respect will be paid to his Czech Roma ethnicity, and where it's likely the parental link will be maintained, or whether he grows up in the United Kingdom as an English boy to become, in adulthood, an Englishman. On this latter foot being realistic, his Czech Roma heritage will either be extinguished or reduced to insignificance. And that is a profoundly important point, which we've been taking much more trouble to think about recently. Largely, I have to say, because of bitter complaints from countries in Eastern Europe about the way in which we are using, or as they would say, abusing our adoption law. But there's a fundamental point there. It all comes back to the same thing. Time was when anybody would assume, well, of course you're better off being an Englishman, brought up an Englishman. And Kipling, in a famous poem, talked of the lesser breeds without the law. But we're not in that world. And in a world, an international world of diversity, it's not for us to say we know better. It's not for us to say children be better off here, if in fact they should be somewhere else. Now, coming down to brass tacks and coming finally to the question which was posed, what do we do about assessing the child in Ruritania? Well, I suppose there are three possibilities. One is we bring the Ruritanian prospective carer over here, or talk to him or her by Skype. Well, that may be an important part of the process, but only a part of the process. Can you actually properly assess somebody otherwise and otherwhere than where they live? I suspect the answer is no. Therefore, one needs, as part of the process, fundamentally, an assessment of the proposed carer in Ruritania. Well, who's to do that? Should it be an English social worker, or should it be a Ruritanian social worker? Well, of course, at the end of the day, there are no guidelines, there are no principles except the child's paramount welfare, and judges will have to decide cases on the particular facts of the particular case. But by and large, I'd have thought, surely the assessment is more likely to be helpful to the English court if it comes from the Ruritanian team and not from the English team. And there are two reasons for that. One is that a Ruritanian social work team will be much more steeped in the realities of life in Ruritania than any English social worker can be. And secondly, and there's no shirking this, it avoids the risk of what may be subconscious bias or prejudice on the part of an English social worker who's accustomed to nice, comfortable, middle class, upwardly mobile, working class life in 21st century England, and may find conditions in Ruritania depressingly different, and in the view of that social worker, even only subconsciously, unattractive. So my instincts to think that one should use the Ruritanian social worker, not the English social worker, and that of course has the advantage that it avoids the risk of the English social worker being put in jail in Ruritania. Now, this of course raises a very real problem, which Karen's very touched upon, about delay, because by and large it is likely to take longer to get an assessment done if an assessment in situ and if it's done by the foreign rather than by the English social worker. I'm told, for example, that the court's timetable is often so restrictive as to result in incomplete kinship assessments in cross-border cases. I'm very troubled by that. If that is so, it is wholly and utterly wrong. Finding the right placement for the child, whatever right means, must come first. And if other things being equal, what the court needs, what is necessary, is an assessment on the ground by a local or non-English social worker, then that is what the court must order, even if the price to be paid is a further extension of the timetable. The issues are too grave, the potential stakes are too high for the child's future placement, happiness and welfare to be potentially put at risk by inappropriate concern about some adverse impact on the court's performance statistics. Now, I don't know why I have to keep on saying this. I've been shouting this message very loudly almost since the day I became president. And the first judgment I gave on this actually predated the introduction of the 26-week rule. It's been twice upheld by the Court of Appeal, and I made it absolutely clear that the 26-week rule cannot apply in a number of different types of cases, one example of which is cases involving an international element where investigation or assessment has to be carried out abroad. We've made it repeatedly clear that 26 weeks has got to give in that kind of case. And the reason is very simple. 26 weeks is only a means to an end. It is not an end in itself, although some people obsessed with performance think it is. It's a means to the end being the welfare of the child. And we cannot allow 26 weeks or the inappropriate application of 26 weeks to cut across the child's welfare. In the printed text I set out all the authorities. We had the point most recently in, I think, was it June of this year, when I was sitting with Lord Justice Ryder. Somebody knows a thing or two about family law, and we were very emphatic that the justice of the case, the needs of the child, must come before performance or statistics. And if that message is not understood, if it's not getting through, then I'm afraid, putting it bluntly, advocates have got to go to court with the authorities in their bags and rub the judge's nose in it. Because if you really go along and say, well, you know, hang on, 26 weeks can't mean 26 weeks, the judge will say, yes, it does. If you then say, well, hang on, judge, the president has said this, and rub his nose in it, you'll then find the judge backpedaling. So that I've obviously not been effective enough in getting the message over. But if 26 weeks and all the other paraphernalia are properly applied, then we shouldn't have the kind of problems which unhappily we obviously do. But from the other point of view, and this again picks up some Carolyn was saying, it does seem to me that we've got to do our best, all the players in the system will do their best to minimise the risk of delay. And what does that mean in practical terms? First of all, at the outset, identifying that this is a case which has a cross-border element in it, at the outset. Secondly, very early on indeed, identifying who the prospective carers are in Ruritania. And then thirdly, very early on indeed, setting in train the process of getting the assessment undertaken. I mean, was it 45?
For an international child protection, it was 45 days.
45 days. Well,
The assessments can take much.
yes, but I mean, the assessment will take how long the assessment takes, but 45 days to set the wheels in motion is simply wrong. And that is only happening because people are not taking the case by the scruff of the neck, are not saying at the outset, this is an international case, this is a cross-border case. Who are the people? And once we've identified this as Ruritania, once we've identified there's an aunt or a couple of aunts in Ruritania, then for goodness sake, why are we taking 45 days to set the wheels in motion? And one final point. I mentioned briefly in passing Article 15. If we're looking to place a child with Ruritanian relatives in Ruritania, why do we assume axiomatically that the decision should be taken by an English court? Under Article 15 and corresponding provisions of Hague 96, and the common law says the same, the English court can say that jurisdiction is better exercised, that the foreign court is better placed to decide the case. And if the real nub of the case is going to be a dispute, an argument, an investigation as to the adequacy of the care which can be provided in Ruritania by some Ruritanian relative, having regard to Ruritanian standards, it's not immediately obvious to me that the English court is necessarily the best placed, to decide that. So always bear in mind that one may need to think about in addition to everything else. Is this actually a case which we should be inviting the English court to transfer, or to invite the foreign court to accept a transfer in relation to? Now, I'm about to shut up because it's important you have your say and ask me questions. But this, of course, all feeds into a much bigger question. Is the English court system adequate at present to deal with, meet the needs of vulnerable children and their families in our increasingly globalized society? Now, that's a very big question. I'd only like to make 3 points before I conclude. The first is one I've made already, that we have learned a lot from reading, watching what our foreign judicial colleagues do, from reading and understanding, or even in translation, foreign assessments and so on and so forth. What that has taught us is that we can, and as I say, we must trust our colleagues abroad, whether our judicial colleagues or our social work colleagues or other public authorities. If we do that, then our system will be better. And I would be, and I'm not making a political point, we must be very careful to make sure we don't lose this modern insight, this modern understanding in the post-Brexit era. It would be a disaster for children in the international family justice system if one of the consequences of Brexit was we all turned into little Englanders and said, you're fog in Channel, Europe cut off, and went back to the way in which we thought about these things 20 or 30 years ago. The second point, coming closer to home, is that the English court system, family court system, is not yet sufficiently inquisitorial. It is said in theory to be inquisitorial, in reality it is not. If you're finding facts, then you've got to have an adversarial system, because you can't find facts except by an adversarial process. At least that's the way we do it. But apart from fact-finding, our system needs to be much more inquisitorial and much, much less adversarial. And that leads into a third point, and it's a hobby horse I've been riding furiously for quite some time now. The English family court system needs to be refocused, rebalanced as a problem-solving system. And if we can do those things, if we can become more inquisitorial, more problem-solving, learning with enthusiasm from the insights we gain from abroad, whether the abroad is Australia, whether it's some redneck judge in Midwest America, whether it's some Eastern European judge, whatever, then so much the better. Now, that's been rather a canter. There's probably been far too much law in that for your liking, but perhaps we can spend the next half hour or so having a discussion. And I was given a great, not a script, but I was given a great list of topics which I might like to care to touch on. And I've touched on quite a few of them, but I think there are some which I haven't yet touched on.
And you've not escaped, because I have them written down.
And I've actually on the list myself. But I thought the idea, before we launched the traditional Q&A, was perhaps if Carolyn and I have a conversation, Carolyn can sort of raise some questions, and then that can sort of move seamlessly into a more general question and answer discussion. So Carolyn, have you any comments, questions, topics?
Of course, first, thank you. That was very interesting, and you've raised a number of points that are quite close to my own heart. The whole aspect of cultural relativism, I think, is very interesting. I know that my team would kick me if I didn't say in this whole conversation around sort of the economic issues versus the sort of emotional, psychological balance. There's also, of course, the wishes of a child and what they want, and that needs to be taken into account. And I do hope that we can get more into that, because I could speak for 5 hours on that. One of the questions, I guess, you've proposed a lot of solutions, which is great, particularly around the 26-week time frame, around the court needing to look at to be a problem-solving institution and to look at the right outcome for a child, and that should be paramount. Regardless, there are an increasing number of cases coming to court, as you've acknowledged and as Sir Andrew McFarlane's acknowledged. And I know from my social workers, social workers are always burdened with so many cases. So between the social workers and the court system, somewhere something's got to give. And I guess my question is really about that growing tension between decreasing the number of cases referred to family court and increasing the robustness of legal orders used to place children, particularly when we found that using the incorrect legal orders or not using legal orders at all has put the child's placement in jeopardy. What can be done? Where's the solution there?
Well, there is no solution to the big problem. I mean, the simple reality is that the volume of cases in the family court goes up all the time. The only slight ray of hope is that the rate of increase has slowed down somewhat in the last couple of years, but the increase has been subject to that constantly upward for in excess of 10 years now. It's the same with local authorities, number of children who they're looking after, whether in care or under Section 20. And then the chief social worker, something to say about that, quite important, quite recently. And we have, it's very simple, we, whether in the court system or in the local authority system, have a constant increase in caseload with, at best, static, and in fact, in local authority terms, declining resources. And that is simply unsustainable. And the system will sooner or later fall over. It took a long time to say the Ministry of Justice was a problem at all. After about 2 years, they did accept it was a problem. We are still not quite sure what's causing the problem, and we're still quite a long way away from finding solutions to the problem. And the fundamental problem, of course, is exactly the same as the problem which the NHS has. In theory, the NHS and the family court system are supposed to deal with every case that comes through the front door, in circumstances where neither the NHS nor the family court system has any control over the numbers coming in through the front door. And the one thing which no politician is ever going to talk about is rationing. And there is actually a very simple question. Let us assume, for the sake of argument, and I think we're just about there at present, let's assume, for the sake of argument, that the family court system, as we currently have it, can only cope with, let us say, 15,000 care cases a year. Let's assume there are going to be no more resources. What do? Well, we either cut corners. Fantasists think we get rid of the family court and we create some new tribunal system that will generate more work for lawyers in a different way. Or one simply says we're going to deal with the 15,000 most important cases. But then the real challenge, and this is what makes it so difficult for all of us, whether we're lawyers or social workers, is every fibre of our being wants to do the best possible job for the child, for the family. The last thing we'll do is cut corners. And what is happening, and this is something which I talk about, the president is talking about, is the consequences that far too many people practice in the system are being grotesquely overworked. Now, in theory, one way we can get a give in the system is to get rid of some of the private law cases which shouldn't be in court at all. And that's something I've always supported in principle. I think there are a significant number of family law cases, cases which don't involve care, which don't involve the state, which really shouldn't be in court at all. And somebody should simply brutally say to the parents, stop wasting our time, grow up, be parents, exercise your parental responsibility and decide what needs to be done for the child. But even if we move in that direction, it's going to take a long time to do it. And meantime, the number of private law cases is going up by about 10% per annum. So that even if we change the dynamic, we'd only be running to stay still.
You mentioned actually just now Isabel Trowler's recent report around care proceedings in England, and she particularly points to potentially a greater focus on pre-proceedings as a way to avoid those cases going to court. I just wonder if you have any thoughts on what that means for international cases.
Well, I have always believed that pre-proceedings work in any kind of law, particularly in any kind of family law, is the way forward. And the problem has always been twofold. First of all, legal problems. You can't legally do anything in relation to a child until the child is born. Well, you can pre-plan, but the system moves into action at the moment the child is born. And the other problem is that any kind of pre-proceedings work will be effective only if it's properly funded. And that, in the traditional jargon of the lawyers and legal aid, means front-loading the funding. And MOJ and Treasury will never accept front-loading because they simply say, well, that's a clever trick by those well-known conspiracies against the laity and the lawyers to get paid double the amount for not achieving anything in the beginning and then getting paid on it goes. But I'm quite sure, I've always been quite sure that pre-proceedings work is vital, because pre-proceedings work would stop cases which shouldn't come to court. It would divert children looking for the care context more quickly and more readily into the right kind of solution. And it would save an awful lot of anguish. But I mean, there are deep cultural, I mean, in terms of the cultures of the English system, there are legal problems and there are funding problems, which I suspect make it unrealistic to think it will happen unless and until somebody manages to persuade government that proper funding of pre-proceedings work is fundamental. You see, even there, I mean, what we have at present on care proceedings is, I'm told, it used to be called green form advice when I was young, but it's some form of legal aid you get before proceedings, where a solicitor can give you, I think it's £150 worth of advice pre-proceedings. Now, in care cases, that right to receive that is triggered by the local authority writing a warning letter to the families saying, we are minded to start care proceedings. Unless they write that letter, the family can't get the legal aid. And if they can get the legal aid, they've still got to find a solicitor in an increasingly legal aid desert. And how much legal advice you get for 150 or whatever it is, 150 quid. So we need a complete sea change in our thinking about this. I think a lot of thinking by those on the ground, those who understand the system, is in favour of doing this. I mean, Trowler said it, McFarlane said it. I think very few people within the system would oppose this. But it's persuading those who hold the purse strings.
To change tack just a little bit, and before we open it up to the floor, I want to make sure those who did submit questions in advance get their answers first. I think I know what your answer to this is going to be, but to be clear, in cases where vulnerable children are ordered to return under the Hague Convention, especially when there have been allegations of abuse and the primary carer is not returning with them, what can be done currently by the UK court and social services, and is there any way of improving the system to ensure children are safer after they are returned under the Hague Convention?
My question when I read that was, how often does that happen? And the conventional wisdom, and I've been involved in Hague cases now for the best part of 30 years, I did a lot at the bar, is endless you get mothers saying, I will not return. If I'm ordered to return, I will not return. You can't make me return. All you can do is order the child to return. If you order the child to return, I will not go back. And the conventional experience and wisdom is, when push comes to shove, mother does go back. Because the more that mother talks up the fact that she won't go back because the man's a monster, I mean, the more she's actually arguing to herself she's got to go back. So I just wonder, I mean, to what extent that is a real problem.
I'm hoping the person that asked this question is actually in the audience tonight, but I'm not going to call them out, so they may be able to give us some examples.
Well, let's
There we go, hi.
So I work for a charity called Wave and we support parents who are stuck in foreign countries due to a relationship breakdown. And so I asked that question because we do see that occasionally, and it is a big cause of concern for us. And because we worry that these children are falling between the gaps in these situations, because the court in the UK, the High Court, will basically presume that the other court will be looking after the welfare of that child. But in actual fact, if the mother doesn't return with that child, there may be no further proceeding. Okay, so that's why
No, I mean, And
think so.
granted the premise, I can quite understand the problem. I just query how often that happens. One of the problems is that from a very early stage in the Hague jurisprudence, way back in the early 90s, and this is actually where the rule first originated in this country, the rule that we've got to trust the foreign country became very deeply entrenched. And I remember I appeared in a case at the bar in the Court of Appeal in 1993, where the argument against the child going back to Israel, and it was Israel, was that in Israel social services and social benefits weren't as good as in this country, there was no legal aid and so on and so forth. And I successfully persuaded the Court of Appeals by looking for authority that none of that was relevant. Israel was part of the Hague system. The Hague Convention didn't take that into account, and you just sent the child back.
Sorry, I missed that.
Well, you just send the child back.
You said the
Well, that's got to be the starting point. And the whole basis of the Hague system is that the issues to be decided by the Court of Habitual Residence and not decided by the court to which the fleeing parent has brought the child. And unless one keeps pretty closely to the basic concept of Hague abduction, one just waters it down altogether. And of course, as you know, as a matter of law, the Hague abduction has been tightened up even further within the EU. And within the EU, it's almost impossible now to establish a case based upon the Article 13b, grave hardship. But I mean, how often does that actually happen?
Well, we actually do have a whole peer support group in our charity full of these cases, and I'd say that there are 20 parents in that group.
These are parents who brought the child to this country. This country then ordered the child to go back to some foreign country, and the parents have stayed here.
Returned to a foreign country from the UK. The mother's not been able to go back, and in many cases she's actually been advised not to go back because there's the risk, especially in the US, that she might have criminal charges brought against her. So the lawyers are actually advising the mother not to go back because she will be put into prison or fined.
But the usual solution to that is to persuade the English judge not to send the child back until proper guarantees are in place to make sure that doesn't happen.
So that's reliant on a lawyer persuading the judge. I'm just wondering whether you think there should be systems in place in that situation to protect the child.
Well, the answer is if there are going to be systems beyond the existence, it's going to involve an adding to the Hague Convention. I mean, I'm surprised you say that, because I mean, I've dealt with Hague cases at the bar, I've dealt with Hague cases at first instance, I've dealt with Hague cases in the Court of Appeal, I've never come across that problem. What I do come across all the time is well-represented mothers saying, if I go back to America, that line of asterisk will have me slung into the county jail, and so on and so forth. And therefore the argument is, before you send the child back, can we please have mirror orders, can we please have undertakings, and so on and so forth. And if father's not prepared to give the undertakings, assuming it's the father, then you lean on him and say, well, I may not be able to send the child back. Now, one problem which I have come across is when the undertakings or the orders prove not to be worth the paper they're written on. And that's why one needs to know what's going to happen at the other end, for one just glibly assumes that something which we would recognise as a foreign order may not be recognised by a foreign country. And there's a particular problem that outside the common law world, people don't have undertakings, don't understand undertakings.
We've got.
I agree. That's our experience of that as well. That unless there's mirror orders put in place, it's not worth the paper it's written on.
Well, I mean, the most recent one I had, which I think was in the Court of Appeal, where we ended up having to put in a substitute order, we did in fact require mirror orders. made absolutely clear the mirror orders had to be in a certain form before the child left.
Thanks. We've got
Can I
about...
I mean, it's slightly off point, but some years ago when I was still at the bar, I was involved in a divorce case as between this country and America. I think it was the state of Oregon. And the American judge who had a transcript of this said after Mr. Justice Johnson, "Who is this man Johnson? Hasn't he heard of a rather important document from 1776? Hasn't he heard what happened at Yorktown? What right does he think he has to be telling me, an American judge in 1996, what I should be doing?" So these things do run deep.
We've got about 10 more minutes before we can continue the conversation over drinks and nibbles, and I do hope you'll join us for at least one glass. But let's see if there are other questions from the audience on any other topics. And now is your chance to get those burning questions. All right, I think we've actually got two over here, and that's, if you wouldn't mind introducing yourself.
Melanie.
I'm Melanie Crew. I'm from CAFCAS, from the legal team. And in relation to the B2A, which you were talking about earlier, one of the aspects of B2RA, whatever, is the enforcement of orders made in this jurisdiction in other jurisdictions. And I would like to ask whether you think we're going to miss that part of it, because my limited experience is that hardly ever have I known an order be enforced that's been made in another European jurisdiction when it comes to either this court or the other European court actually being enforced. Somehow it's always found to be against public policy or not properly litigated in the other jurisdiction. Are we actually going to miss that part of B2F if we don't keep it after Brexit?
Well, Melanie, I'm surprised to hear you say that. There's a stack of English authorities which are very emphatic that the public policy let out is very, very narrow, and that we've got to enforce these orders.
I mean, again, my experience is limited personally, but are they being enforced in reality? I don't know.
Well, the answer, Melanie, I would confidently say we don't know, because I'd be pretty confident there are no relevant statistics. Nobody's done any proper research. We simply don't know. And I suspect, strongly, what we think we know is simply a mixture of anecdote, assumptions, and either pessimism or optimism. Certainly as a matter of law, we've been very emphatic that the public policy exemption is very, very, very narrowly drawn.
Yeah, I absolutely agree, but I would be concerned that that somehow that ideal arrangement where you don't have to put a child through even more litigation maybe doesn't work in practice. And again, I don't know, and there apparently isn't statistics, and if we're not going to get this after Brexit, it won't matter anyway.
I suspect, Melanie, rather 6 months, I suspect it depends more than it should on the combination of two things. Have you got lawyers involved at all? And of course, if it's private law, you won't. And secondly, are they on top of all this stuff? And a lot of lawyers are not on top of the intricacies of article this, article that. And secondly, and this thing would say, but I suspect it's true, it depends on the judge. And some judges are much more rigorous and actually apply the principle that we enforce the order. And there's a famous case, I think James Housman, in one of the early cases, he'd been approved in the Court of Appeal, said there's no way I would ever have made this order, but that's not the question. This order was made, and I've got to enforce, I'm going to enforce it. And I suspect it's very easy for judges to slip into thinking, well, if I wouldn't have made this order, I should find some way of getting out of it.
My question is quite different. I'm I'm an independent social worker and work a lot with various organisations, including Social Workers Without Borders. And my question is about separated asylum-seeking and migrant children, who are both subject to immigration control and very much outside the jurisdiction of family courts. They have no family here. I've been working with some eminent people in the legal profession who are advocating for a single court which would deal with both the welfare and the immigration elements of their situation. I just really wonder, first, what your thoughts are on that, and secondly, if there's any real, genuine likelihood of it ever occurring.
For my thoughts on it, I can simply refer you to a lecture I gave to the Howard League in, I think, November last year, where I advocated precisely that. And more recently, in a lecture which I gave in Liverpool, I said the family court should become a one-stop shop, not merely picking up a point that Brenda Hale has made, that in one set of proceedings, one hearing, you should be able to deal with the divorce, the money, the children, everything together, rather than having a succession of different hearings. But a one-stop shop covering both family law and other things. And immigration is one obvious one, and youth justice. I mean, why do we have the family court? Why do we have the youth court? Sometimes dealing with the same seriously damaged teenagers, and often I gave the details in those two lectures, coming up with mutually conflicting orders. So I'm very strongly of the view we should. The good news, and I don't think I'm speaking out of turn or disclosing anything which isn't out there, although they may not be appreciated. Following on my Howard League lecture, I had discussions, I as president had discussions with Ernest Ryder as the senior president of tribunals to see whether we have some way of marrying up in relation to children, the family justice system and the immigration and asylum system. And he was supportive of that, and it hasn't yet reported, but we set up a working group which I think has 3 family judges and 3 immigration asylum judges who are trying to come up with practical solutions. We'll never get the two systems put together, because the idea that the Secretary of State of Justice and the Home Secretary will agree on anything is absurd. But what we're trying to focus on are things which the judges themselves can do by way of marrying up directions, trying to make sure the cases slot in together. Appropriately, one could have joint directions hearings where the 2 judges sit together and at one hearing give directions in relation to both parts of it. And why not, in an appropriate case, have 2 judges conducting a single hearing? We've got to think outside the box. The system is profoundly unsatisfactory. And we have this sort of, the law, of course, is quite different. The family court, the court is concerned with the paramount welfare of the child. The welfare of the child is not paramount in immigration. It is an important factor, it's not paramount. And there's well-established case law showing that even if a family judge has said at the end of a long hearing, the child's welfare is best served by the child remaining in this country, living in this country with the parent. That doesn't bind the Home Secretary, doesn't bind the tribunal, and the parent can be deported. That, I think, is right. We can't change that. What I think we could do, much more to do, is to try and smooth the processes so that we had a more beneficial process in which both parts of the system, both systems, could understand what the other was doing and be trying to match up what they're doing. One problem is the family justice system doesn't know what the immigration system is doing, and vice versa. And the reason is very simple. Family lawyers don't understand immigration law. And I've lost count number of times. I used to sit in the admin course, I do up to a point understand. I've lost count number of times I'd say in a family case, now, you say the child is subject to this. Where have proceedings got in the tribunal? And I'd then be given some answer which legally was impossible, which has demonstrated a complete lack of understanding. When one of the first things I did as president, together with I think it was Lord Justice Sullivan, who at that time was the senior president of tribunals, we put together a protocol trying to manage some of these things between the immigration system and the family justice system. It hasn't worked. And there's now fresh emphasis on doing it. So watch this space, but don't imagine that the ultimate outcome will be quite as good as you'd like it to be.
Some of us are still optimists, though. I think that's all that we have time for. I'd love for us to put our hands together for Sir James Munby.